I said, which is the sequel of all this and all that has been preceded, is to the following effect, that the wives of our guardians are to be common, and their children are to be common, and no parent is to know his own child, nor any child his parent. Those words are from Book 5 of Plato's Republic. They were quoted in a famous Supreme Court case a little over 100 years ago. Thankfully, the Supreme Court did not follow its advice, nor does really anyone follow it today. But those words pertain to an issue we're going to discuss today that just came up at the Ninth Circuit about parents and their children. All that this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, June 10th, 2025. So once again, we come to June. June is the time when there's all kinds of legal news buzzing around, a lot of it often because of what's going on at the U.S. Supreme Court. But here on Short Circuit, we don't care all that much about the U.S. Supreme Court because we're all about the Federal Courts of Appeals. And we have some news from the Federal Courts of Appeals for you today. We're going to be joined in just a moment by a special guest who's going to be talking about a case of his from the Eighth Circuit that came out a few months ago and has now been remanded, is about to go to trial. So exciting news there. We'll hear about that in just a moment. But first, I want to introduce someone else, my friend and colleague here at IJ, Michael Bindas. Now, Michael is head of our educational choice work. He's been on Short Circuit a number of times, but I realize I kind of have let some things slip, and he hasn't been on, I think, in a couple years. So, Michael, very sorry for the long delay, but we're very glad to have you back.
Well, thank you for having me, Anthony. I think the last time we did it was the live recording at the Law Student Conference a couple of years ago.
That could be, yeah. I think we had you on around that time, and then we had, right after the Carson case came out, yep. We did a little victory at the U.S. Supreme Court, so there was an exception with the Supreme Court. So we'll get to Michael a little later about a unusual case for him. We're going to talk about a qualified immunity police shooting case, which you think usually we'd have Anya Bidwell or Patrick Giacomo on to talk about, but it actually has this interesting parents and children's rights angle that we'll be discussing. But first, I wanted to say something really quick before we get to our special guest, and that's so many of you across the land, I know many lawyers listen, but people of other walks of life listen too. Many of you probably work in places where you write reports. So maybe you run a department, maybe you just run like a small group, or you're the secretary for someone who runs a group or something like that, and you have to write like a report. Maybe it's a weekly report, quarterly report, whatever, to your superiors, to your board members, whatever. And, these are things that are important, and I'm sure everyone, all of you, put good time into them. But we don't think of them as like classic works of literature. When you go into your public library and the old dusty shelves, you're not going to see department reports in there. But Michael is the exception. Michael takes a little bit of je ne sais quoi into his weekly report. And I can say I stand for many of us at IJ that we look forward to those every Friday. And there's always a little something of like a pop culture reference that I have never heard of before. And I realize I'm even more uncool than I thought I did, but somehow Michael knows about that. So, Michael, how do you produce these amazing things?
Well, first off, I have to double check myself every week before I hit send, wondering is Scott going to fire me this week if I hit send on this? I don't know. I've got this like a mind that's capable to recall, Charo being on the Tonight Show, with Don Rickles as the other guest, but I can't recall, what I need to focus on at work tomorrow. Like I just have this uncanny ability to remember late 70s and 80s cultural references that I, for some reason, think other people will be interested in or find entertaining. The fact that you often don't get them, I would not say is a mark of you being uncool, Anthony. I think the one last week had to do with the song Convoy by C.W. McCall. And I played that for my wife and kids shortly after I sent out the weekly report, and it's decidedly uncool. So you're not missing anything.
All right. Well, maybe I won't Google that one, but I have had to Google a number over the years, and it's always kind of delightful actually when I have to. So we'll see if any listeners have to Google anything that you say in a little bit. First, though, we're going to talk to Dan Cragg. So Dan is a partner at a law firm called Eklund and Blando, which is in Minneapolis. Now, he's going to be talking today about a case that involves some this First Amendment discrimination and some Title VII issues. But Eklund and Blando's real bread and butter is suing the government when they renege on their contracts, which is kind of a big deal. Government has a lot of contracts. Now, we don't do that work here at IJ, but we are fully supportive of the government being bound to its obligations, whether they're in the Constitution or they're in a contract they signed and promised to pay you. So, Dan, could you just tell us a little bit, like, what is that world like where you have all these clients who, they get in to some extent in business with the government because the government's so big, it has all this money to spend, they got to do it. And then, if they say, well, we don't want to do that, but you can sue us and we have sovereign immunity. What's that whole area of law like?
Well, okay, so the one good thing is we do have a big, giant sovereign immunity waiver for contract claims. And we even have a specialized court in the Court of Federal Claims in D.C., which is a national court. So it's one of the few trial courts that's going to give you a national bar license, essentially, to go and practice government contract law anywhere. But beyond the sovereign immunity issue, keep in mind that the federal government it doesn't negotiate any of its contracts. It, in fact, has a whole code of regulations of contract clauses that the contracting officer just checks the box for when he lets the contract. And if he fails to check the correct box, the court will deem that clause part of your contract anyways if it finds it fundamental to federal government contract law. And in terms of performance, you can have issues where, as the contractor, you'll have a disagreement with the contracting officer as to whether something is in scope or not. And unlike a normal private party contract, when the contracting officer says, "I think I'm right, go out and do it," you have to go do it and then sue the government for the money. You don't get to say, no, we need to reach an agreement on this change order before we do anything. They say, no, you have to do it and you can sue me later. And almost all contract issues, it's on the contractor to actually submit a claim to the contracting officer, including to defend themselves. And then from there, you go either to the Board of Contracting Appeals, civilian or military, or you can go to the Court of Federal Claims, which applies a slightly modified federal rules of civil procedure and appellate jurisdiction then to the federal circuit after that.
And with states, it's largely the same, right? But it differs a little state by state. And some are a little, I know Minnesota's a little unclear, like what rights you even have, but they just kind of go with it.
States are much less organized in many ways to their detriment on this. But yeah, you sometimes have these unclear issues of sovereign immunity waiver in states. And actually, my firm actually had a big hand in putting together the ABA 50-state guide to government contracting.
Oh, wow.
And it's amazing how thin some of the states are. And I think the reason that is because I think a lot of state agencies around there know that they actually need these contractors to survive and, show up next year to pave the roads again. And so they can be pretty good about working some of these things out. But not to get too off track, I had a case in district court in St. Paul, which was a settlement agreement breach of contract, where the district court said there was no sovereign immunity waiver for the settlement agreement and dismissed it for lack of jurisdiction. And somehow while it was on appeal, ordered us to a settlement conference with her, and I had to explain to her, Judge, if we enter into a settlement agreement again today, you've already held that you don't have jurisdiction over this and I can't sue the state for it. So how is this going to work? And I asked her to approve a consent decree to do it. And I can't even remember how I think we resolved that, but I don't remember if she actually entered the consent decree. But it was one of those things where you're with the judge without the other party because it's a settlement conference, and she realizes that her ruling doesn't make any sense.
That's kind of a fantasy that so many lawyers maybe have. But you actually got to be there.
Yeah.
Well, let's talk about another ruling that doesn't make any sense. And that's what you've been doing in the Eighth Circuit. So this is an opinion. So we're going to talk about an opinion and the rest of your case. It came out last December, but then there was a remand, and it's going to go to trial soon. And a lot going on here, but it involves some First Amendment retaliation issues, which of course we do here at IJ. So we're very interested in what you have to say.
Okay. Where do you want me to? You want me to start with the facts of the case in the trial court? You want me to go right to the opinion?
Yeah, I think maybe a quick summary of the facts of the case, and then we can get to what the Eighth Circuit said, and then what's happened since.
So my client was the chair of the OBGYN department at what's now called Hennepin Health Services. It used to be called Hennepin County Medical Center. Hennepin County is the county where Minneapolis is. And HHS is, it's a very large public hospital. I think their revenues are in excess of at least $1 billion. It might be $2 billion. They're what you would regard as kind of a public social safety net hospital for the area, trauma hospital, learning hospital, et cetera. And the doctors that work there, I mean, they make great salaries for a public employee. I mean, I think they're pretty competitive, but there also is the type of doctor that wants to work there may have kind of a social justice goal or bent to them. And my client, for most of her life, was totally on board with that. I think she would have described herself as a liberal. And then 2020 rolled around. And so during all the lockdowns and they're changing processes and things like that, she started to express some opinions on her personal Facebook page that became controversial within her department. Now, 5 years later, they're now regarded as kind of true statements. Like she said things like, it seems like COVID originated in a lab, and gosh, the Chinese government is covering it up. And for that, she was called a racist, for saying that. Of course, the FBI, the CIA, Department of Energy have all made findings basically saying, yeah, we think it originated in a lab. She also, in talking about the riots in Minneapolis after George Floyd's murder and all that, she was like, I'm not in favor of defunding the police. I don't think that's a good idea for the groups of people that we serve here. And, of course, the young doctors who, of course, have 2 college degrees are saying like, well, that's really racist. You need to get on board with this.
And for context, I mean, some of these riots were literally around the hospitals that HHS runs.
Yeah. And one of the things they really got mad at her for is a lot of them joined a group called White Coats for Black Lives, which is an adjunct to the Black Lives Matter organization. And they were going to rallies in their HHS doctor uniforms. And she said, whoa, we're a public hospital. Like, you can't wear your uniforms to a political rally. You can do that on your own time, but you can't make us associated with that. And that was kind of her on-the-job statements. On her personal Facebook, she's also pointing out, like, hey, this Black Lives Matter organization is a Marxist organization, according to their founders, and I'm not on board with that. And again, the response to the doctors is, oh my God, she's a terrible person. I don't want to work with her, and all that. And so eventually, these doctors were able to get management to perform. It wasn't pitched as an investigation, but they brought in like some HR people to do a survey, climate survey, and the climate survey came back with, we think you should just get rid of her, which was beyond their mission and everything. And then it goes through the bureaucracy. The bylaws say your chair can only be demoted when the medical executive committee, which is essentially the other chairs, vote on it. And then that has to be ratified by the board of directors of the entire hospital, which is important for our case to understand. And they asked her to resign. She refused. And then the issues all went up to the medical executive committee. They had a big 80, 90-page packet that included some of her personal Facebook posts. And they voted to demote her. And then that went up to the board of directors. And in discovery, we were told that there was a short 10-minute or so presentation. They didn't have any of the Facebook posts. It was kind of pro forma. And then something else happens after we get to the Eighth Circuit, but I'll go chronologically. And I'll also note, we had the case was really tough from a procedural discovery sense, because our magistrate judge held us to 10 depositions or so. I think she may have given us a couple more, but we had, a group of 10 to 12 doctors in the department. We had, another 10 people on the medical executive committee, another 10 people on the board of governors. And all of these people are relevant to like what happened and the decision. And so we couldn't depose everyone. We tried to, and the judge said, nope, you're stuck. You can only do 10. And so we had to make a lot of decisions, which now when you're actually trying the case and you have transcripts for some and not for others, it makes it more difficult.
Sure.
So that's essentially what happened in the trial court. And we went in for summary judgment. They're being defended by the Hennepin County attorneys because it's HHS it's a separate corporation, but kind of subordinate to Hennepin County. And they moved for summary judgment on our First Amendment retaliation claims and also the Title VII and Minnesota Human Rights Act discrimination claims that we made. Minnesota Human Rights Act is the state Title VII, essentially. And Judge Susan Richard Nelson dismissed all of the claims, the Title VII and MHRA on the merits, but on the First Amendment retaliation, she only addressed Monell liability. And Anthony, for your audience, should I explain Monell liability?
Just real quick. I think most people out there know a little bit about it, but yeah, real quick.
Yeah. Okay. So when you bring a claim under 42 U.S.C. Section 1983, this is the Civil Rights Act that passed after the Civil War, sort of to enforce the new constitutional rights in the 14th Amendment, et cetera. It specifically references that any person is liable. And so the Supreme Court has held that vicarious liability does not attach to Section 1983 claims. And so the only way you can sue something like a county or a government corporation is when the final policymaking authority, as defined by state law or its rules, either does the constitutional violation or approves and ratifies it. And so it was undisputed in our case that the board of directors is the final policymaking authority for HHS. And we had taken a 30B6 deposition where the representative for HHS said that the board of directors approved the decision by the medical executive committee and the basis for it, which is exactly what we need to prove for Monell liability. Like the question and answer was perfectly lined up for what we need to prove. And it was and the MEC, or the medical executive committee, had the Facebook posts that we were saying you retaliated against her for. And Judge Nelson called our 30B6 admission a slender reed upon which to base our case.
That I get flashbacks to so many IJ cases where we've had 30B6 of, cities or whoever saying basically the same thing. And yeah. Anyway, go on.
And I've seen this. This happens in civil cases with some regularity where the judge doesn't like your case and you've got some damning admission and the judge dismisses it. And we're under a preponderance of the evidence burden of proof. And you have to say, Judge, we convict murderers in this country based on confessions beyond a reasonable doubt. How is it that in a preponderance of the evidence standard, a sworn testimony deposition is a slender reed? Well, she dismissed the whole case, and we went up on appeal. Of particular note for your listeners is during the pendency of the case, I and my client had been guests on the Megyn Kelly podcast to talk about the case, and Megyn had asked me, what do you think of your odds basically in the district court? And I said something to the effect of, I think we're going to have some trouble in the district court, but I'm confident the Eighth Circuit will go our way. And the Hennepin County attorneys actually put that in the summary judgment brief that I think I'm going to get my case dismissed, but win at the Eighth Circuit. And so we went up to the Eighth Circuit.
Then I'm not going to ask you that question because
Okay. I mean, it's the same answer, I think. But we went up to the Eighth Circuit. We had an interesting panel led by Judge Loken, who has got to be one of the older judges on any federal circuit at this point. I could be wrong. I think he might be 90 or close to. And we argued it in June of last year, and we didn't get a decision until December. But what is perhaps most interesting about the opinion, and I'll tell you, the result is we did get a reversal on the First Amendment retaliation claim.
Judge Logan is 85, by the way.
Okay, sorry, Judge Logan. He's 85, not 90.
Spry.
Spry.
85.
We got a reversal on the Monell issue, basically saying that obviously this record, we've got this admission. There's some other things here that we had pointed out in the brief, like 2 members of the board of directors were also on the MEC. And so at least 2 of them had it. And so they said, this is a triable issue. And went a little further to invoke the Pickering balancing test for public employee retaliation claims, kind of giving the district court some instruction, and went even further and said that clearly she was speaking on a matter of public expression, and you might need to impanel a jury on whether there was disruption in the department with special interrogatories. And I think we'll get to kind of how this is playing out on remand. I can talk about that more fully. And so he gives us this great First Amendment retaliation reversal. And then we get to the Title VII and the MHRA claims, and he punts. And what he says is, well, we've already reversed on the First Amendment retaliation issue. And so now the rest of this is really an interlocutory appeal. So we're not going to address it. Of course, the district court on remand can revisit its summary judgment decision. But we don't see any need to do any further review here. So go back to the trial court.
So to be clear, the district court had addressed the merits of the Title VII and the state claim?
Yes.
So they were just as addressed as the First Amendment stuff.
Correct. Actually, more addressed.
Well, right, because that was just Monell on First Amendment.
Right. They were more addressed fully. It was at both sides, full briefing. Like we were ready to go on that. The oral argument spent most of the time on the Title VII argument.
Right. So the delicate question is, how could the Eighth Circuit think that's interlocutory?
I think this is a quirky idea that Judge Loken has, that we only, if we're doing a middle of the case appeal, even from a final judgment.
But it's not the middle of the case. It's final.
It was final.
It's a case that could have gone further. It could have gone to trial, but it didn't. It's over. If you hadn't filed the notice of appeal, it would have been history.
Yes, you are. I think Judge Loken is wrong on this, but in an effort to steelman the argument, he is taking a view that if you are appealing from summary judgment and not post-trial, and we find one issue to reverse on, we're not going to touch the rest until after trial. And so to be clear, the Title VII and MHRA claims, we still get to appeal when we get to the next final judgment. Those are still happening.
But are they going to trial?
No.
So when you appeal, say you lose at trial, you will be appealing First Amendment trial judgment and summary judgment on the others. And so in theory, you could lose on First Amendment on appeal, but win on the others and be remanded for another trial.
Correct.
Well, that sounds efficient.
It's very efficient. And remember the rule against piecemeal appeal that we're trying to deal with, right? So, which is why I think Judge Loken is frankly wrong. And I also, maybe this is an unwarranted inference, but this is a 12-page opinion. It didn't take from June until December to do this. I imagine what they were fighting over was this, now it's interlocutory part of the appeal. And eventually they gave up on convincing Judge Loken otherwise and just wanted to get this out.
Okay. So it's remanded. And now you've done a little more discovery and its trial's coming soon?
So we haven't really done any more discovery, but we had one big thing happen, which was very interesting in that when we were talking about trial witnesses, really on the Monell issue, saying like, well, I'm going to have to call the whole board for trial. The assistant Hennepin County attorney reached out to try to get availability for people. And in talking with the general counsel at HHS, and this is all in the public record in the case, everything here. The general counsel apparently said to him, well, why do you need them to testify? Can't you just use the video? And the county attorney says, what video? And we learned that this pro forma meeting testified to, or they didn't talk at all about my client's views and things like that was actually a 30-minute portion of the board of directors meeting that was recorded on Microsoft Teams, where they were very much aware and concerned about my client's political views. At least one member said, "Why are we just demoting her? Can't we terminate her?" To which the president of medical affairs, who's doing the presentation at both the MEC and the board, says, "Well, she's a fantastic doctor. She has 5 pages of accomplishments. Like, this isn't an HR issue where we can terminate her. You know, it's in his view a leadership issue. You know, or really it was they had the other doctors essentially staging a coup. You know." And so this is produced to us, and I give full credit to the Hennepin County attorneys for doing the right thing on this, disclosing it, taking responsibility for it. But we did move for sanctions against their client, HHS, because if the general counsel was aware that this video exists, clearly it should have been turned over in discovery, and they didn't do a good job collecting things. And what smart's even worse is one of our 30B6 topics for examination was their ESI collection activities. And Magistrate Judge Foster said, "I'm not letting you do discovery on discovery." So she entered a protective order for that. So the court had stopped us from getting to the bottom of this, and lo and behold, here it is. Okay.
Is that now in the record? It'll be introducible at trial, or you got motion in limine on that?
So here's the most interesting part of the remand for your listeners. Okay. So under Pickering, this is the First Amendment retaliation. Most of it is a decision for the court. It is a question of law, essentially the balancing of the public employee's right to free speech against the disruption in efficient government operation the Supreme Court has held. That's a question of law for the court. The subsidiary fact questions still need to go to a jury because of the 7th Amendment. And so what Judge Nelson did is she bifurcated the case. So trial 1, coming up on June 23rd, is solely on the Pickering issues, where the jury will be given special interrogatories about disruption and things like that. And we're going to have a second trial, assuming she doesn't dismiss it, on essentially causation and damages. So at least in my view, the decision to demote her is not relevant to the Pickering analysis. The Pickering analysis is about disruption within the department. So that video will not be part of the first trial.
Gotcha.
It will be part of the second trial,
Okay.
and I don't think there's going to be any dispute about it. I mean, it's the evidence of Monell liability, right? It's the decision.
Right.
Yeah.
So interesting. And so Pickering is a case we've talked about from time to time. It's, I think, from the early 70s. It's when the Supreme Court said that the First Amendment applies to public employees and their speech in some way. It's interesting. We just did a couple episodes, a case about a Tinker issue. So Tinker is a case from just a few years earlier about the First Amendment applying to public school students and their speech. And in some ways, it seems like, Dan, this is a little bit of a sidetrack, but in some ways, it seems like the issue's kind of similar, that these people, whether they're students or public employees, they have First Amendment rights. They can say certain things, but if what they're saying, especially if it's at school or in the workplace, causes some disruption, then that's where we need to pay a little closer to, the government gets a little bit more of hands-on.
Correct.
Yeah.
I will say, though, I think this is where Pickering is worth talking about, because we have preserved the issue of overruling Pickering, because I think when it comes down to it, and I think we've got good facts for this, Pickering, unfortunately, is the heckler's veto, except going the wrong direction. But the context is very different from students, kids, and actual
Definitely.
public employees who are adults who you can tell to drive on and not cause trouble over something, right? And so in my case, what we have is, I think, we have medical doctors who should be mature professionals throwing a tantrum because their boss has a Facebook page they don't like. Okay. And if the department was disrupted by that, I just don't see that as justifiable, consistent with the First Amendment, to say, when the junior employees don't like what the boss says on her own time, they can stage a coup and threaten to quit, and that's fine. I mean, that is the heckler's veto, right? Kids obviously have a little less agency there. And so saying the kids being immature and reacting to something and causing a problem, I'm fine with that. I get that. And also kids, they're required to go to school. They're not employees. They're not hired. They're not paid. But telling your public employees, hey, you need to be a professional and go back to work and stop looking at your boss's Facebook, in my view, is the right way to resolve this. And I think they should apply strict scrutiny, essentially, instead of this Pickering balancing issue.
Well, Michael, you've done a few First Amendment cases in your time. You've also, I know, had some remands and reappeals in various areas from time to time. So curious to your response to this.
Yeah, I want to get back to this kind of philosophical and maybe theological question of when you assess an appeal's interlocutoriness. If I'm understanding this correctly, the appeal, the actual thing you notice, was not interlocutory because there was a final judgment disposing of all claims. But at some point during the pendency of the appeal, perhaps when the panel authored the penultimate paragraph of the opinion, it then became interlocutory based on what had preceded the penultimate paragraph. I want to make sure I'm getting this correctly.
You are, except I think it's a little worse than that. Like, you're right that it was a fully final judgment dismissed case. But the First Amendment analysis is not the penultimate paragraph, okay? But as I read this, and not to be too flippant here, I'm assuming they were writing in Microsoft Word. What they're basically saying is that when they finish the paragraph on First Amendment retaliation and click the return bar, the case has now become interlocutory.
So I don't know what rule of appellate procedure is it that we may need to revisit in light of this.
I mean, the only thing I can think of is there are courts all the time will affirm or rule or reverse or whatever on one claim and say we don't now need to reach the other claims because this claim is good enough. Now, usually that's in the context where the whole case is over, right? Like the party A has won, so we don't address the other things they're appealing about.
Because they're not going to get any more relief.
Right. Here, I don't get how it. This is the case because the remedy is to be remanded for the case to go on. You would address the other claims.
You would, and also these claims all get different relief. So it matters.
So you could have a series of non-interlocutory appeals that become interlocutory and kind of go through an endless cycle until you exhaust the 6 or 7 claims at issue in the case. Is that kind of in the cards here?
We could have 7 appeals to get to the actual finality in this case. Which, there is a fee statute for all of these claims. So I guess if we do that, it's going to eventually.
Judge Loken's just trying to help you out in that regard.
Well, we have a lot going on here. We have Pickering, we have the retaliation itself, and then we have this interlocutoriness. But what is the timeline? You have the trial just about the start on the first issue, and then the next one even scheduled yet?
The court wanted to schedule it in August, and the attorneys did say, "Please, Judge, can we not go to trial every other month?" And have requested a fall date
in a Minnesota summer.
Yeah, please don't take away 2 of our summer months, Judge. And she's considering that so far, I think. Hopefully we'll go to October or November on that. Between you and me and your audience, I think she's going to dismiss the case again. I'm not sure she intends to get to the second trial yet.
All right. Well, Judge Loken's standing by for when you get back to the 8th Circuit. I don't know if it would be the same panel or not, actually, how the rules would work.
Only if by accident, because you're given a calendar, and that's the panel for your calendar, right?
Yeah. Right.
I was just gonna say, but the meter's running on your fees the whole time, so it's all works out to your advantage.
If I win.
Sure. We'll know in
7 years.
Yeah. Judge Loken will be 92 at that point.
Well, that's some great stuff going on in the 8th Circuit, complicated. But of course, one rule of appellate procedure is it will be even more complicated in the Ninth Circuit. And so that's why we're turning to Estate of Daniel Hernandez versus MLH, a minor, which will be a big deal in a moment. That's this Ninth Circuit case. As I said, when you read the first few paragraphs, it sounds just like a lot of the qualified immunity cases that we've talked about on the show, and even some that we litigated at IJ. But it takes this interesting angle in one of the concurrences, and Michael's going to tell us how it does that.
Sure. So to start off, Anthony, I have to correct you with the caption of the case. It's not Estate of Daniel Hernandez versus MLH, but rather Estate of Daniel Hernandez and MLH versus the city of Los Angeles. And this will become relevant because MLH is the minor daughter of Daniel Hernandez.
Right.
And this will become relevant when we get to get into this. But so this case involved a police officer shooting and killing of a criminal suspect, Daniel Hernandez. Obviously, given that context, the lead claim here was a Fourth Amendment excessive force claim. And we'll talk about that here in a bit, the qualified immunity aspect of that. But that's not why I chose this case to talk about today. I chose it because this past week we celebrated the centennial of Pierce versus Society of Sisters, which is kind of the canonical case, U.S. Supreme Court case, along with Meyer versus Nebraska, that recognized the right of parents to direct the upbringing and education of their children. And as you noted at the outset, I do a lot of work in the educational choice space, and Pierce is therefore one of the most significant cases that we do in advocating for school choice programs and other programs that empower parents to direct the education of their kids. So the listeners might be thinking that's all fine and well, but how in the world does this police shooting in the Ninth Circuit implicate Pierce and Meyer? So we'll get to that, but first let's briefly recount the facts here. So the case arose when two LA police officers arrived on the scene of a multi-car collision. There were a bunch of people, they say about 25 people on the side of the road. They were screaming and yelling, saying that there was a crazy man, that's one of the quotes, in one of the trucks involved in the collision, that he had a knife. They got a radio call. The officers got a radio call saying that there was the suspect was armed with a knife and was threatening to kill himself. The officers could see the suspect apparently rummaging around the center console of the truck. And at that point, the suspect exits the truck, kind of hides behind the truck for a little bit, I guess. The officers or one of the officers is repeatedly calling out to him, "Let me see your hands." After a while, the suspect emerges from behind the truck. He's shirtless. He's sweating profusely, which led the cop to believe that he was on meth, which turned out to be true. But in any event, the suspect begins walking in the officer's direction. The officer initially backs up 10 feet and continues yelling multiple times to drop the knife. Instead of dropping the knife, or what turned out to be a box cutter, the suspect kind of extends both of his arms and continues walking in the officer's direction. So after the officer yells one more time to drop the knife, she fires 2 shots at the suspect. The suspect falls to the ground, but I very quickly rolls over, kind of reorients in the direction of the officer and starts climbing up and gets about halfway back up to standing. The officer yells again to drop it, fires 2 more rounds. The suspect falls back again on the ground, and as the majority in this en banc opinion describes it, kind of crawls up into the fetal position and rolls away from the officer. And the officer fires 2 more rounds after that, and the suspect at that point collapses and remains down. And it turns out that last shot was fatal. So the entire episode lasts barely over 6 seconds. And the parents of the deceased, Daniel Hernandez, as well as his minor daughter, file lawsuits against the city, the LAPD, and the officer who fired the 6 shots at Hernandez. And of course, the lead claim is a Fourth Amendment excessive force claim. They bring a municipal custom and policy type claim against the city and the police office, the police department, a variety of state law claims, and then finally interference with the right to familial integrity in violation of the 14th Amendment. More specifically, the parents of Daniel Hernandez bring a claim alleging abridgment of their right to companionship with their son. And the daughter of Daniel Hernandez, the minor daughter, brings a claim alleging abridgment of her right to companionship with her father. So, and obviously that last claim is where Pierce and Meyer will tie in here. But we'll talk briefly about the main claim, the excessive force claim. So the district court had granted summary judgment to the officer, holding, number one, that the use of force was reasonable, it did not violate the Fourth Amendment, and that alternatively, the officer would have been entitled to qualified immunity even if it had violated the Fourth Amendment because the law was not clearly established. A three-judge panel of the Ninth Circuit affirmed in part and reversed in part on that claim. The panel said that the question of the reasonableness of the use of force was a triable issue of fact that should have gone to a jury. But regardless, the officer was entitled to qualified immunity because, again, the law was not clearly established that what the officer had done was unreasonable. So the family petitions for en banc rehearing in the Ninth Circuit, and we get a very divided decision that comes out last week.
Which, as I always like to say, is en banc. The Ninth Circuit is not actually en banc, but is 11 of the 29 active judges of the Ninth Circuit.
So a little over a third en banc.
Right.
Right. Okay. So
en banc-ish.
So what the majority agrees with the panel decision insofar as saying that there was a triable issue of fact as to the kind of reasonableness of specifically the fifth and sixth shot. So the panel or the en banc majority agrees with the officer and the LAPD that she acted reasonably with the first four shots. So these shots came in kind of 3 2-round volleys. And the en banc majority says the first two, and although a closer question, the second 2 shots, the officer was acting reasonably because the suspect, with the first 2 was standing, moving toward the officer with the box cutter, and even after those first 2 shots, was trying to get back up, orienting in the direction of the officer. And so the majority says reasonable up to that point, but as for the third volley of 2 shots, the fifth and sixth, the officer there, or a jury could reasonably have found at that point that the suspect no longer posed a threat to the officer, and the officer had a duty to reassess as this situation was playing out whether the suspect was incapacitated or instead still posed a threat. And that question should go to the jury, whether the officer should have known at that point, based on reassessing, that there was no longer a threat. The en banc majority also concluded that if the officer did continue to shoot and the suspect no longer posed a threat, then the officer would not be entitled to qualified immunity, because it's clearly established in the Ninth Circuit that an officer can't reasonably continue shooting at a suspect when he's on the ground, wounded, shows no sign of getting up, et cetera, et cetera. So that's the majority, en banc majority. Judge Collins, in a concurring in the judgment, dissenting in part opinion, agrees that there is a triable fact question as to whether the last 2 rounds were unreasonable. In fact, Judge Collins had authored the panel opinion, so he kind of reiterates that. But he says the final 2 shots did not violate clearly established law, and therefore, in his view, the officer was entitled to qualified immunity. And then finally, there's a third opinion authored by Judge Nelson, but joined by Judges Gress, Bumate, and Bade, who agree with Collins that there was no violation of clearly established law, and therefore the officer was entitled to qualified immunity. But they would have gone further and said that there was no Fourth Amendment violation at all, that no reasonable jury could conclude that there was a Fourth Amendment violation. And basically they say that in a situation like this, where this plays out in 6.2 seconds, I think, is the entirety of the 6 shots in a very high intensity situation. There was no obligation to kind of reassess in between each round that was fired. They say that the duty to stop firing only arises if an objectively reasonable officer would view the suspect as clearly incapacitated. And here the suspect had just tried to get back up, was still moving after the 4th shot. They actually disagree slightly with the en banc majority's take factually about what happened. The en banc majority said the suspect was curled up in the fetal position. Judge Nelson sees it more as kind of bringing his knees to his chest in a kind of motion of repositioning to raise himself up on his forearms.
Seems like one of these, this is video too, so it seems like one of these cases we've talked about before where the judges read the video differently, and that's right, which to me means, well, it seems like that's a question for the jury because they disagree on the facts, but that was their take. Yeah,
and then, then finally, Judge Nelson points out what he sees as a kind of perversity in the en banc majority's reasoning, in that he says, I'm quoting him here, he says, it discourages any reassessment. When in doubt, the officer should now continue shooting or risk liability. Not a great message, unquote. So basically what he is saying is that that if as the majority holds, there was an obligation to reassess between shots 4 and 5, the incentive for officers is going to be not to pause between shots 4 and 5 or between 1, 2, 3, 4, 5, and 6, but just to continue shooting until, for lack of a better words, the kind of deed is done, and the suspect is not just the threat is terminated, but the suspect is terminated. So it's an interesting issue. It's a very, very unfortunate factual circumstances. But the Fourth Amendment issue and the QI issue is, again, not why I chose this case to talk about. It is because of the tie-in to the centennial of Pierce. And when you asked me to come on, Anthony, I was thinking, all right, we've got this 100th year anniversary. Let's see what great parental liberty interest cases we have. So I do a quick Westlaw search, and the most recent case was not a parental liberty interest case, but this Fourth Amendment excessive force case out of the Ninth Circuit. So, how does Pierce tie in here? So, as I mentioned before, the parents bring as their kind of wrap up claim in the case a claim for abridgment of their right to companionship with their son. And the minor daughter of Daniel Hernandez likewise brings a claim for companionship, loss of companionship with her father. Now, and they claim that this liberty interest in companionship with their son and their father is protected by the Due Process Clause of the 14th Amendment under the kind of substantive due process doctrine. Now, the panel, the Ninth Circuit panel, and the majority had disposed of this claim by saying, like, even if there is this 14th Amendment right to companionship with your adult child or your minor, or of a minor with her parent, the officer's conduct didn't shock the conscience, which is kind of the test that courts will often apply to assess substantive due process claims involving executive rather than legislative action. Right. And here, police conduct in a situation like this would be viewed as executive, and therefore the en banc majority says, even if there is this 14th Amendment protected liberty interest, the conduct here didn't shock the conscience and therefore ruled against the parents and the daughter of Daniel Hernandez. Judges Nelson, Bress, and Bumate would have gone further, though, because they questioned whether the parent of Daniel Hernandez has any liberty interest in companionship with their adult child, and they questioned whether the minor child of Daniel Hernandez had any liberty interest in companionship with her father. So not just a matter of whether, the kind of relevant shocks the conscience threshold had been met, but rather they questioned whether there was a liberty interest at all implicated here. As Judge Nelson puts it, the Ninth Circuit has stumbled its way into recognizing these substantive due process rights, and he urged the court to reassess those earlier decisions, recognizing a liberty interest in companionship with an adult child and of a child with her parent under the Glucksberg test. Listeners, I'm sure will be familiar with the Glucksberg test, which is the U.S. Supreme Court test to discern whether a claimed liberty or right is fundamental and thus accorded meaningful protection under the Due Process Clause of the 14th Amendment. As Judge Nelson noted, the Ninth Circuit had not conducted a Glucksberg analysis with respect to either of these two types of companionship claims, and he urged that the court needed to do that and not continue, again, as he put it, stumbling into a recognition of these asserted due process rights.
Because we can't have that.
No, yeah, right.
Recognizing rights.
Crazy talk. So what does the Glucksberg analysis involve, right? First of all, it's a two-step process. First, the court has to kind of carefully describe the asserted fundamental liberty interest, meaning, describe it with, not just assess it at some broad kind of high level of generality, but describe it with kind of particularity, with specificity. And then second, assess whether it was objectively and deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. Now, again, Judge Nelson noticed that the Ninth Circuit had never conducted this type of analysis. He acknowledged that parents have a liberty interest in the upbringing and decision-making regarding their minor children, and he cites Pierce and Meyer for that proposition. But he notes that most circuits have rejected attempts to extend that right into one recognizing a right to companionship with an adult child as opposed to a minor. And then as for a child's right to companionship with her parent, so here Daniel Hernandez's minor daughter's claimed right to companionship with her father, Nelson noted that Pierce and Meyer rest on a kind of historical tradition that parents have authority in the custody and care of their children, and that this kind of parental authority is what gives rise to the parental liberty interest recognized in Pierce and Meyer. And he goes to so far as to say that this parental liberty recognized in Pierce and Meyer is not really premised on a concept of parental rights as it is on parental duty, the right or the duties that a parent owes to a child. And then he says it makes little sense to transform these two cases, Pierce and Meyer, cases about parental authority and duties, or even rights, if you say they're about rights. He says it makes a little sense to transform those cases about parental rights into cases about children's rights. And he says, this is kind of the key line from his opinion, if children do not have a duty to care for their parents, why would they have the corresponding right to enjoy their parents' companionship? So we can talk about that quote here in a minute, but the bottom line is Nelson urges the Ninth Circuit to kind of at some point reassess their recognition of these rights and in light of Glucksberg. And I find this interesting for three reasons. One of which is that quote I just read from Judge Nelson's opinion. But before we get to that, I think it's important to recognize that Glucksberg was decided in 1997. As Judge Nelson notes, it requires identifying the claimed right at a very kind of specific, particular level in order to determine whether it's this claimed unenumerated right is protected by the 14th Amendment. But in Meyer itself, the court began its entire analysis by noting that it had, quote, that it had never, quote, attempted to define with exactness the liberty that the Due Process Clause protects. And it goes on to say, without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. So this approach from Meyer seems to stand in stark contrast to Glucksberg itself, right? Today, the court concerns itself with kind of, myopically defining the right at a particular, level of specificity in order to determine the particular level of scrutiny that applies to a claimed abridgment of that right. But in Meyer, the court says we've never attempted to define with any exactness the liberty protected because it's a very capacious idea. And so I find that the Ninth Circuit or Judge Nelson's opinion here very interesting because it involves an attempt to apply Glucksberg to what the court has called kind of the oldest of the liberty interest recognized under the 14th Amendment. And in the cases recognizing this oldest of the liberty interests, the court took an approach that's almost antithetical to Glucksberg and just presumed liberty broadly rather than attempting to define a claimed right at an exacting level of specificity. The second thing I think is really interesting is that today Meyer and Pierce are certainly recognized as cases dealing with parental liberty or parental rights with respect to their children. But they weren't brought by parents. They were brought by educators, right? Robert Meyer was a teacher. The Society of the Sisters of the Holy Names of Jesus and Mary were a religious order that operated private schools. And certainly the court in those cases protected the rights of parents who wanted to send their children to the schools where Meyer taught and where the Holy Name Sisters taught. But the court just as much was concerned about protecting the rights of Robert Meyer and the Holy Name Sisters themselves. And it went out of its way to recognize their rights to provide services to parents, to contract with parents for the provision of those services, which again just reinforces this idea that Meyer and Pierce were not concerned about myopically focusing on the particular right at issue because the court recognized that a law can abridge liberty in many different ways and implicate many different rights. So again, it just draws this interesting contrast between the Glucksberg approach and Meyer and Pierce, which recognized the oldest of these liberty interests. And then, of course, there's that sentence from Judge Nelson's opinion: if children do not have a duty to care for their parents, why would they have the corresponding right to enjoy their parents' companionship? I find that curious because if the law does impose a duty on parents to care for their children, I think it can be reasonably argued that children have a correlative right to receive that care from their parents and a right to claim against the state when the state does things to abridge or interfere with that care. So it's a really, really interesting and surprising issue to come up in the context of a case involving a police shooting. But I think it's a very good illustration of the uncertainty that still exists out there among the lower courts in particular about what Meyer and Pierce truly mean, what they are about. There's a lot of confusion about the scope of the rights recognized in those cases, about the level of scrutiny that applies for claimed abridgments of those rights. And I think at some point the Supreme Court is going to have to clarify some of that. I have no idea whether it would be if either side plans on petitioning for cert in this case, but it's just after a century of Meyer and Pierce, there's still a lot of confusion among the lower courts about what those cases actually stand for.
So, Dan, you have children who I would hope feel duty towards you. Any thoughts you have about this issue or otherwise of this case?
Let me say first, I'm fully on board with the notion that parental rights and duties are anterior to government. And when the government goes interfering in the family, there should be some level of constitutional scrutiny to that. But I do think that the Ninth Circuit has sort of lost the plot here in how far they've gotten, because what they're really talking about is sort of a derivative type of loss of consortium claim.
Yeah.
Which is just, it's way too far afield. Well, let me put it this way. If they're going to hold that such a claim exists in a 1983 Fourth Amendment action, okay, fine, because I'm sure you could find some support for the notion that American common law recognized such a claim in the late 19th century. But those claims are not independent. Like, you need to prove the underlying, in another context, you need to prove the underlying intentional tort or negligence for, say, the wife or the kids or the husband to recover. And many jurisdictions will treat it more as an element of damages than a separate cause of action, and things like that. And it seems that's what, if we're talking about a shooting where there's going to be, I assume they still think this interference with familial relations claim is going to have to prove the underlying Fourth Amendment violation. And Michael, can you speak to that? Or can you literally, if a cop, shoots your family member, can you just bring a straight up, you've interfered with my family, or do you have to prove the Fourth Amendment violation?
Yeah, I don't know that the opinion got into that, although I believe, I'd have to go back and confirm, but I believe part of the reason for dismissal of, well, no, it was the state law claims that the court said, that are kind of intertwined with the Fourth Amendment claim and failure on one. But
it was wasn't it that at the panel level, the 3-judge panel, they said that there was no substantive due process claim because it didn't shock the conscience.
Right.
Yeah. But let's say, even without the benefit of the opinion, we know they go to shocks the conscience when you haven't defined the right at all, right?
Yeah, well, I mean, the thing is, even say Mr. Hernandez had survived and he would bring a substantive due process claim where there's no question about this, having parents, relations, all that, then it's still just straight up the shocks the conscience. So I think maybe what is getting at here is you need to shock the conscience about the substantive due process right that was violated vis-a-vis him. And then we're a question of, well, who can then kind of benefit from that as a relation? And that is kind of its own substantive due process question.
Yes and no, because the Supreme Court in other Section 1983 contexts is fine with importing state tort law. For example, it imports the state law statute of limitations. It imports the state wrongful death statute. I think it would be totally consistent with Supreme Court case law to say you can bring a loss of consortium type claim under 1983 that you're borrowing from state law in your jurisdiction, much like the wrongful death statute.
True, although I think there you would have to analogize it to some kind of constitutional claim, which is often done.
Oh, the Fourth
which I think
Amendment
you're
claim.
getting at. Yeah, like the Fourth Amendment claim.
And to state it a little more plainly, I think if there were no Fourth Amendment violation and a police officer shoots a family member, that can't possibly be a constitutional tort. Like they didn't shoot the person intending to interfere with familial relations. They probably had no idea he had a family, and which is why I think, again, the Ninth Circuit is just way too attenuated in its reasoning.
Well, you could come to that conclusion by two ways, though, right? There's is there a right implicated at all, a constitutionally protected right implicated at all, or applying whatever kind of scrutiny is appropriate to assessing a potential violation of the right that the officer didn't was justified, for lack of a better word, in shooting. So you could defeat the claim either of those ways, I would think.
You could, but again, it seems to me it just comes back to this is a derivative type of damages.
Yeah.
That's how you solve this without creating a brand new constitutional right.
And I think for the parents of Mr. Hernandez, that seems pretty, to me, it seems kind of clear. So that, if anything happens to an adult, can the parents of the adult, if they're still around, would they have a claim for, loss of consortium, as you put it? And that does seem to be really a kind of a state law tort issue. It doesn't seem like Meyer and Pierce, I'll put it that way. But this is the big meat of the issue. But for the daughter right? Does she have a claim? So put it in different contexts. Say she is living at home with her dad, and the state comes up and takes her dad away with no due process, no charges, they just disappear him, right? Say he's a U.S. citizen, whatever, they disappear him. Would she have a claim, a substantive due process claim for that her rights were violated, in addition to whatever claims he would, of course, have against the state? That's where I think there seems like there's a problem, because, of course, if she was taken away, then it seems like that's in the Meyer and Pierce zone. And if he's taken away, doesn't she have some kind of like corresponding constitutional right to have, the state not make it so she doesn't have a parent, basically? And I get the line. So the way they get around that, right, Judge Nelson gets around that, is this line about that's only with duties, which really rubbed me the wrong way. And this is why I opened with the lines from Plato's Republic. So at Plato's Republic, and by the way, which is not probably what Plato actually thought. It's like there's a lot of layers going on in the Republic. But the argument put at this point by Socrates is that, okay, so no one's going to have everyone's going to be taken away from their parents. The state's going to raise them. Everything's going to be great. No one's even going to know who their kids are. And so you'd have no duty towards your children at that point, right? Okay. Well, what if we had like modern day America where you know who your parents are, but they're just pass a law that says you have no duties to your kids. It's like you don't have to provide for them anymore. You can give them up to the state if you want. And so I say, you know what? I like my kids, and I'm going to keep doing whatever I do anyways. Okay, so I have no duty, but I'm still going to provide for them. And because, it's just kind of the natural thing you do prior to the state, like you were saying, Dan. At that point, do I not have a constitutional right to direct the upbringing of my kids because I don't have any duties anymore? Seems absurd. And so that's just a thought experiment. But it seems to me on the flip side, the child has a right to have the parent around, vis-a-vis the state not interfering with having the parent around, even if the parent doesn't have a duty there. I don't know. Maybe that's too many levels of, philosophy going on. But if this becomes more of a thing in some other case, and I get this is just a few paragraphs and wasn't briefed all that much into concurrence, I think that there's those other considerations you would not want to look into.
It certainly involves philosophical questions as deep as the interlocutoriness issue that we were discussing before. I mean, I don't know if Plato had anything to say about that, but...
Let me answer I'll try to answer your question this way, Anthony. I mean, I think you've got a good thought exercise there, but what I'm coming back to is the right of the family or its independence from governments must be defined in a way specific enough, because everyone is somebody's family member, right?
Yeah.
Like that status alone can't give rise to some tort against the government. It must be the government actually in some way going after the family unit, be it a law that takes the kids away and sends them to boarding school without due process, et cetera, something like that. But to simply say that, you injured my dad in the course of something that who cares if he's a parent gives rise to a claim doesn't make sense to me.
Understood. And one other way to think about it, and I think this might be along the lines of what you're saying, Dan, is in Meyer and Pierce, we talk about the rights of parents, but really what's going on is the right of the child. But the child, of course, doesn't have either the wherewithal or the cognizance or whatever to be able to stand up for their rights. So the parent is guiding the child and saying, no, you are going to go to a school where they teach German. And that is that is my right. I'm trying to protect. It's not the kid who's actually saying, I want to go speak German, but in some ways at core, it's the good of the child. And so we say we defer to the parent for the good of the child, not to the state. And that's the right we're talking about. And so in maybe in other contexts, we're really talking about the right of the child. And so anything else is just kind of this layers that are not best addressed by the Constitution, perhaps.
Let me try to reframe what you said just a little differently. It's not actually about the rights of a child. It's a recognition that recognizing the power of the parent to direct the upbringing is on the whole going to be better for the child than the government doing it. But it's certainly not guaranteed to work out that way in every instance.
No.
It's a system where we're saying, not to be too utilitarian, but like kids are going to be better off with parents making the decisions. And there are going to be some bad parents, but and the kids with the bad parents, it's not that their rights are being infringed or something. It's just the way humans should operate in the system of ordered liberty.
Right. And we do that. The Constitution does that by recognizing what we call the rights of parents.
Yeah.
But I think there's other rights going on there. And I am also right that we have gone way too long. But I hope the audience have been interested in what we have to say. Thank you, Dan. Good luck at your trials as they may be happening. Thank you, Michael. And we should raise a glass to the 100th of Pierce, as we did a couple years ago at the 100th of Meyer. And everyone else, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.